The Court of Appeal has confirmed that Alex Belfield has made an application for permission to appeal against his sentence after being sentenced to 5.5 years on various stalking offences. So I'm going to talk a little bit about what that means and what might happen in this video. The Court of Appeal said that this is at the very early stages. So welcome back, and if you're new to me, I'm a barrister who helps you understand law, so please hit that like button and subscribe at any point you feel during this video. So all of this came to light at a hearing with the trial judge in respect of an error during Belfield's sentencing, particularly in respect of count 5. That was the charge with respect to Bernie Keith. Now, Alex Belfield was sentenced to 2.5 years in respect of this, but it turns out that the court was advised that the maximum sentence was 5 years, when in fact the maximum is 10 years. But the trial judge, Mr. Justice Saini, said that the Crown made no submission that the sentence was inappropriate or unduly lenient, going on to say that bearing in mind the need for overall proportionate sentence and the principle of totality, he was not satisfied that the final sentence of 5 years and 26 weeks would have been substantially higher had he been made aware of the correct legal position with respect to count 5. Now, this comment itself might prove very relevant if permission to appeal against sentence is granted and the appeal hearing goes ahead, because some of you felt that Alex Belfield's sentence was too lenient and others of you felt that it was too harsh. But given that the Court of Appeal said that this application is still in its very early stages, it's impossible to comment any further. Now, when one is convicted in the Crown Court, one can appeal against conviction, against sentence, or against both. So in this case, it appears that Alex Belfield is appealing against sentence. Now, it's important to understand that there is no automatic right of appeal against sentence from the Crown Court. Unlike some of you may be aware that there is an automatic right of appeal from the Magistrates' Court to the Crown Court, whereby the Crown Court will conduct a rehearing, effectively, of the trial from the Magistrates' Court, only it's with a judge and 2 magistrates, not a judge and a jury, in the way of an appeal hearing. But from the Crown Court, there is no automatic right to appeal against sentence. There must be a good reason. These are known as grounds or grounds of appeal. For example, if there was an error in the law or procedural irregularity, for example, the Crown Court passed a sentence which was not permissible for that particular offence, then somebody could appeal against sentence on that basis, but that doesn't appear to be the case here. Secondly, somebody could apply for permission to appeal if it appears to them that the sentence was too long. That would seem to be the case here, although I haven't had any details confirmed. It's also important to understand that this is generally a fairly high threshold, and that the court must be satisfied that the sentence was out of all proportion in the circumstances with respect to the offence, the offender, and everything else. Finally, it is also open to the prosecution to appeal against sentence if the Crown believes that the sentence was too short. But given the comments in court, that isn't obviously the case here. Once an application for appeal has been submitted, a High Court judge will consider the documents available and decide whether or not to grant permission, sometimes referred to as leave. Leave to appeal is the same as permission to appeal. If permission or leave to appeal is granted, then the appeal is heard orally with a 3-judge court. If, on the other hand, permission is refused, then the application for permission can be renewed orally before, again, a 3-judge court. Although it's also important for anybody applying for permission to appeal to remember that if an application to appeal or a renewed oral application for permission to appeal is deemed to be wholly without merit, in that there is no real merit in the application or renewed oral application at all, the judge can make a loss of time direction under sections 29 and 31 of the Criminal Appeal Act of 1968. This means that a specific amount of time that has already been spent in custody will no longer count towards their sentence. But as always, if I learn any more that's appropriate to discuss with you, I will come back and do an update video as and when we learn that information. In the meantime, please do like this video and subscribe, and as always, thank you for watching.